Hello friends, this is Arundhati Bajpayee for Tax Publishers, and in today's session we will discuss an interesting issue relating to Section 129 of the CGST Act. Section 129 of the CGST Act deals with detention, seizure and release of goods and conveyance in transit. As per subsection 1 of Section 129, where any person transports or stores any goods while they are in transit in contravention of the provisions of CGST Act or CGST Rules, all such goods, document and conveyance in transit are liable to detention or seizure. The goods so seized can be released on making payment of penalty specified under Clause A or B of subsection 1 of Section 129 or on furnishing of security specified under Clause C. Subsection 5 of Section 129 of the CGST Act provides that on payment of amount referred in subsection 1, all proceedings in respect of the notice specified in subsection 3 shall be deemed to be concluded. In this regard, the issue for discussion is whether, where a taxpayer makes payment of penalty for getting the goods released, the proper officer is relieved of the duty of passing of order under section 129 subsection 3. As of now, where any goods are detained and the taxpayer makes payment of penalty for release of goods, the goods are released and no order is passed by the proper officer in form GST MOV 07 on the ground that after making payment, all the proceedings in respect of the notice stands concluded. In the above eventuality, tragedy of the taxpayer is that in the absence of an order under section 129 subsection 3, he would not be able to file appeal before the appellate authority. In the case of ASP Traders versus State of UP and others, the Allahabad High Court has fortified the view of the department by holding that once the proceedings in respect of notice under section 129 subsection 3 of the Act stood concluded, in terms of section 129 subsection 5 of the Act, revenue officer is not required to pass an order under section 129 subsection 3 of the CGST or UPGST or GST Act. However, recently the Kerala High Court in the case of Hindustan Steel and Cement has held that whether or not a person opts to make a payment under section 129 subsection 1 clause A or to provide security under section 129 subsection 1 clause C, the responsibility of the officer to pass an order under subsection 3 of section 129 and to upload a summary of the order or demand in form MOV 07 continues. The High Court further held that it is always open to the person who suffers the proceedings under 129 of the CGST or SGST Act to challenge those proceedings before the appellate authority if he feels that the demand has been illegally raised on him. It is clear from the above discussion that merely because a taxpayer makes a payment of penalty under section 129 for getting his goods released for business exigencies, it does not mean that the proper officer is relieved of passing of order under subsection 3 of section 129. Thank you.